Good evening, everyone. I hope everyone is doing great. Thanks for joining in. This is Karishma Malhan from Taxmann's Research and Advisory Team of Indirect Tax. I'm hereby joined by my colleague Sunil Kumar and, of course, Raghuraman sir, expert speaker with us. And we all will be discussing about the recent Supreme Court judgment of Bharti Airtel. So before starting the webinar, here are a few tips for the attendees. Please note that the copy of this presentation will be emailed to you after this session. And you can post your queries in the chat box given on the right-hand side of your screen. So the flow of this webinar would be as such. First, we'll discuss about the return filing system under the GST, followed by facts and arguments in the case of Bharti Airtel. Observation and conclusions of Delhi High Court and Honorable Supreme Court would be discussed. And finally, analysis by Raghuraman sir. And we'll discuss all the queries of our viewers at the end. So, if we look at this case of Bharti Airtel, so the issue majorly revolved around the tax filing, return filing system under the GST. And of course the claiming and availment of ITC. So at the time of introduction of GST law, a new return filing system was basically introduced, where the registered person was required to file a number of statements and furnish numerous details in this statement. So let's discuss how this return filing system works. So first, supplier is required to file the details of outward supplies in Form GSTR-1, which is required to be filed on or before the 10th of the succeeding tax period. So as we all know, currently the due date of filing Form GSTR-1 is actually 11th of the next month. That is because power has been given to the commissioner to extend the due date of this return. So all the details which are furnished by the supplier in Form GSTR-1 are actually communicated to the recipient in Form GSTR-2A. From there, the recipient can actually verify, validate, modify, or delete all these details and furnish Form GSTR-2. In this form, other details such as RCM transaction, import of goods, etc., are also required to be furnished. So any claim of ITC in GSTR-2, which is completely matched with the details furnished by the supplier in his GSTR-1, is finally accepted and communicated to the recipient in Form GST-MIS-01. Now, let's discuss about the situation where the supplier misses to report or furnish any detail in his Form GSTR-1. So in such cases, the recipient can actually add such detail in his Form GSTR-2, and these details, along with any detail which is corrected by him in GSTR-2, are made available to the supplier in Form GSTR-1A. Now from there, supplier can either accept or reject such informations or details. So where these details are accepted, the outward supplier accordingly amended in his statements. Whereas any discrepancy or any detail which is not accepted by the supplier is communicated to both the supplier and the recipient in Form GST-MIS-1 and Form GST-MIS-2 respectively. This all is being done in the same month in which returns are required to be filed. So notably, any discrepancy which is not rectified in the supplier within these time limits is actually added to the output tax liability of the recipient in the succeeding month in which the discrepancy is communicated. This is actually according to Section 42, which tells us about the unmatched ITC. So to summarize this whole return filing system, GSTR-1 is filed by the supplier to report his outward supplies. Recipient then matches these details with the purchase register and make modification in Form GSTR-2, which is accordingly communicated to back to the supplier in Form GSTR-1A. So any mismatch between GSTR-1 and 2, ITC in such cases is allowed provisionally, but but the output tax liability of the recipient would be increased where such discrepancies are found. Now, this whole process, which I just explained, is just, as I said, is carried out in the same month in which the returns are required to be filed. Now, what about the errors or omission which are actually noticed in the later period or the later stage? So, for this, GST law actually provides for manner of rectification of Form GSTR-1, GSTR-2, and GSTR-3. So these provisions are in front of your screens. So I will discuss these provisions one by one. So Section 37 discusses about the 37.3 discusses about the rectification of the details of outward supply. So details which remains unmatched. This is to be noticed that only unmatched, which are details which are unmatched under Section 42 and 43 due to error or omission are rectified under this section. And where liability is increased, taxes and interest are required to be paid accordingly. Section 38 discusses about the rectification of details of inward supply. Now, where details remain unmatched in 42 and 43, these are, these are required to be rectified in the period in which such error or omissions are noticed. Now, notably, this phrase that when these errors and omissions are noticed is not provided in Section 37.3. So now Section 39.9 talks about rectification in Form GSTR-3, and where only omissions or incomplete particulars are rectified in this section. So if we note, the cases where the ITC or the claim of ITC is required to be rectified by the recipient, where would he actually report these rectification, whether it will be reported under Section 38 or 39. So as far as the return filing is concerned, Form GSTR-2 provides table number 12, where such details are required to be furnished, which are actually auto-populated in GSTR-3, like you can see in table number 7. Now, in this similar, in line with these provision, Circular 7, dated September 2017, was issued, which actually provided that any differences can be corrected in that particular month to which such differences pertains. So, it was also provided in this circular that eligible ITC, which is recorded in GSTR-3B, and it is less than the ITC which is shown in GSTR-2, then it will be correctly reflected in GSTR-3 of that very much month. Now, later, another circular was issued in December 2017, where it was provided that this previous circular, which I actually discussed about, was kept at abeyance, and it was provided that Form GSTR-3B can be corrected only in the month in which the errors were noticed. So this is all about the return filing system under the GST law. Now my colleague Sunil Kumar will talk about the facts and arguments of the case. Over to you, Sunil, sir.
Thanks, Karishma. Thanks for explaining the return filing system under the GST law. So the facts in the Bharti case were like, they had a centralized registration under the service tax regime, and under GST they have taken registration in all the states and UT, that is on pan-India basis. For the initial 3 months after GST implementation, that is July, August and September, they argued that they had claimed a lower ITC in their GSTR-3B based on estimation, and the output tax liability pertaining to that lower ITC was paid in cash. This amount was somewhere around 923 crores, which was later discovered in September 2018 when Form GSTR-2A, the auto populated details of inward supply, made operationalized. Now, the Bharti Airtel sought rectification before Delhi High Court for allowing rectification GSTR-3B for basically allowing the ITC to be claimed in the respective month of July, August, September, and the cash they had paid in that particular GSTR-3B, that would be allowed to be refunded to them. Now, one may have a question that why rectification is needed in that particular month only, since you can utilize this ITC against future liability also. So, what was the need for seeking a rectification in that particular month? For this, they have provided a fact which is very important. They said that their future output tax liability would substantially going to be reduced because of low tariff in telecom sector, and further the ITC for future period would also going to be increased. So this 923 crore would going to be some sort of working capital blockage for them. That's why they sought rectification in that particular respective months only. So the arguments which they have taken for allowing this rectification before Delhi High Courts were, they said that the new scheme, that is a GST scheme, provides the entire mechanism system of matching, etc. From section 37 to 43, it was required to be followed. It is a statutory right of the taxpayer to fill these details, that is details of outward supply, inward supplies, etc., which cannot be prejudiced due to inability of the GST system to carry out all these things. The ITC was in any case available. It was not reflected in the GST system due to lack of data on GST system. There were system-related checks in these returns 2A, 2, 3, etc., which if had it been operationalized, it could forewarn the petitioner about the mistake which they had done in the respective periods by utilizing the ITC instead of that they have paid the tax. They have also argued that GSTR-3B is just a manual return where there are no checks and balances, and that's why the excess payment of tax went unnoticed. Law basically, there is no enabling provision under the GST law which allows them to rectify such returns in the respective period. The law 39.9 or the matching concept which is there under the GST law, it provides the validation or matching of the things in the same month itself. It is only the unmatched things which goes to section 38.5 or 39.9 which you are required to be rectified in the respective month when you notice the errors or omission. If you are not allowing such rectification in the same month in which you found that particular error, then this disallowance would be some sort of disallowance would be contrary to the provisions of the GST law. Lastly, they argued that Rule 61.5, which prescribes about GSTR-3B, and the circulars dated December 2017, which provides you to make rectification in the month in which you identify the error or omission. These both are ultra vires to the statutory scheme. They have placed few judgments before the Hon'ble Delhi High Court. First is Aap and Company of Gujarat High Court, where the High Court held that GST-3B was not a return, it was just a temporary facility. Few other judgments were also placed relating to Tran 1 issue, where different High Courts have categorically held that GST is in its trial and error phase, and they permitted in different cases to rectify and revise the returns to the taxpayers. The last argument which they have taken in before the High Court was that if you allow us the revision, it would be a revenue neutral situation because we have already paid the tax as required under the GST law. So it would be some sort of a revenue neutral situation. Now, what were the arguments of the revenue before the Delhi High Court? Revenue argued that Section 39.9, which basically allowed the rectification relating to GSTR-3, it provides that the changes which you want to incorporate due to error or omission, which you have found at a later date, you can make such incorporation in the tax period when you notice such error. So assessee cannot reflect these things in the original tax periods, and therefore this circular, it is December 2017, it is in line with the statutory provisions which allowing you to make the rectification in the month when you find such errors. If you make any changes in the original return, it would require modification by the recipients, etc. also. So this would increase the compliance burden on the recipient also. So, and last argument they have taken is that GSTR-3B is not in addition to 3, but it is in place of 3. So this is a return also. What Delhi High Court have observed and concluded, Delhi High Court observed that the statutory scheme under the GST law provides the verification, etc. in the same month only. It is a self-policing system under the GST law where things are auto-populated, verified, and confirmed by both the parties in the same month. This procedure is a right and a facility to the registered person, which ultimately, ensures that you are claiming the correct ITC. There are two stages of rectification. First stage of rectification is given under 42-43, by which you matches the entire ITC of yours with the output tax liability of the supplier. If things got unmatched, as Karishma has explained to you, this would either be communicated to the supplier by 1A. If he is not accepting, then the law would under section 42 would reverse your ITC by adding the amount in your output tax liability. So at first stage, things will automatically get matched as per the law only. The second stage of rectification is given under section 37(3) relating to outward supply, 38(5) relating to inward supply, and 39(9) relating to GSTR-3 details. And these are the unmatched details. So first stage would be relating to the matched detail, where rectification, etc. would automatically be there. And for second, the things which you find at a later date. The High Court has noted that GSTR-3B is only a summary return, since 2 and 3 could not be operationalized. The statutory scheme which is there under the law, it has not been put into operation in its entirety as envisaged in the GST law. If 2 or 3 had been operationalized by the government, the petitioner would have known the correct ITC during the relevant periods, and it could have discharged the accurate tax liability by using the available ITC to it in the electronic credit ledger. Since system was not working, that's why they have paid the amount in cash. There are no refund provisions under the GST law, which allows the assessee to claim the refund under this circumstance, which is a peculiar situation. High Court has also noted that with introduction of 3B, the original scheme which is there under the Act is fundamentally got altered. There are no checks and balances in GSTR-3B, which ultimately, may result into inaccuracies, etc. Making all these points, the High Court held that the circular dated December 2017, which allows the rectification in the month in which you notice the error, etc., it is contrary to the scheme of the GST law, because GST law matches these things in the respective month only. Rectification, the High Court has also noted that there is no provision under the GST law which restricts such rectification. On the point of revenue, that if you allow the rectification in the same month, then it would increase the burden on the recipient. On this point, the High Court held that you need to see each case separately, where if there is an absurd outcome for any given situation, you cannot take any benefit because of the same if it was genuinely available to the taxpayer. So High Court overall, held that the para 4 of this December circular, which is allowing rectification in the month when you notice the same, it is ultra virus to the statutory scheme, and they allowed Bharti Airtel to rectify the returns in the respective month. Now, revenue went to the Supreme Court against this case. what additional argument revenue had taken before the Supreme Court. These are as under. But before that, if you see the High Court observations and conclusion, it went in a single way, whereby they are entirely relying on the self-policing system under the GST law. They haven't even discussed about the self-assessment concept, and this given a clue to the revenue to argue a very important point of self-assessment before the Supreme Court. So they argued that under the law, it is the responsibility of the taxpayer to maintain the books of accounts and discharge the output tax liability accordingly on the basis of self-assessment. The revenue also argued that the common portal, that is GST system, it is only an enabler, facilitator to bring all the registered persons together. Its problems that it is not working would not release the obligation of registered person to self-assess the tax liability. Discharging the tax liability either using the cash option or the ITC, it is only a facility, an option given to the registered person. This matching concept, which is there under the GST law, it is only a facility. They argued that GSTR-3B, though it's a stop-gap arrangement, was always treated as written under Section 39. And the last point they said, if you are allowing the rectification, then there would be a sweeping of entries required, sweeping from credit ledger to cash ledger, for which there is no enabling provision under the GST law. Now, one point Bharti Airtel has also argued before the Supreme Court, which is very relevant. If you see Delhi High Court's judgment, where revenue argued that the circular dated December 2017, the power of it, basically the points which it is explaining, it is flowing from Section 39(9). For this, read carefully Section 39(9). It starts with the point subject to Section 37 and 38. 37 is the details relating to outward supply, and 38 relates to details of inward supply. So Bharti Airtel argued that if 38 was not put in place, how you can rely on Section 39(9) by saying that the power is really flowing from Section 39(9), it is not getting implemented at all. What the Supreme Court has observed and concluded, Supreme Court, heavily relied on the arguments taken by the Revenues Council that under the GST law, yes, the registered person is required to maintain the books of accounts, etc., and it is the responsibility of the registered person to self-assess the ITC, tax liability, etc. They have compared the GST scheme with the erstwhile. They have compared the GST self-assessment scheme with the erstwhile indirect tax self-assessment scheme. They held that there is no difference in manner of determining the output tax liability which you were doing under the service tax regime or maybe the excise regime. In a similar fashion, you are also required to discharge your output tax liability and claim the ITC accordingly. So there is no difference. There is nothing new came into picture. Very important observation. The Supreme Court held that common portal GST system is only a facilitator to feed and retrieve information, and it is not a primary source of doing self-assessment. Very, very important. They had that circular dated December 2017. It is not contrary to 39(9), which provides error or correction in the month when you notice the same. Since there is no provision under the GST law for such excess, so there is no provision under the GST law for claiming refund of such excess tax paid. As argued by the revenue that paying using the credit or cash, it is just an option. The Supreme Court, observed that the same point that output tax liability, payment of output tax liability in cash, it's just an option exercised by the assessee, which cannot be reversed at a later date. Because law is, if you reverses it, then you would require to reverse the entry from electronic credit ledger to cash ledger, for which there is no provision under the GST law. Very important, the Supreme Court, noting the judgment of Gujarat High Court of AARP and Company Chartered Accountants, they held that they have a categorically view that GSTR 3 is written for all purposes, and they have twice, highlighted the point that validity of retrospective amendment has not been challenged before us. The judgments which were placed before the Delhi High Court relating to Taxmann, on this point, the Supreme Court held that you cannot compare Taxmann issue relating to GST portal with the sweeping of entry. In this case, if we allow rectification, then sweeping of entry would be required from electronic credit ledger to cash ledger. So these two things actually are altogether different. The law allows you to rectify the detail only when you notice. So they are heavily relied on 39.9 in order to conclude their views. There is no denial of the ITC, but you can claim the same in the subsequent months. Again, they have agreed on the revenues point that if we allow the unilateral rectification, then it would affect the other stakeholders in terms of their obligations and liabilities, etc. So, basis this overall points, the Supreme Court held that since you are supposed to follow the self-assessment scheme, and therefore we are set aside in the judgment of Delhi High Court, and rectification would not be permissible during the respective month. So if we see the overall judgment of Supreme Court, it went into one particular direction, that is self-assessment scheme under GST. The High Court and Supreme Court, went on to do different directions. The Supreme Court has, not analyzed in detail the self-policing system, the matching system under the GST. On the other hand, Delhi High Court has not considered the self-assessment scheme. Now, I request Raghuraman sir, because I have few very interesting questions relating to this document, and I want the respected views of Raghuraman sir on these. Sir, first question of mine is, what are your views regarding the validity of this December circular, which basically allows the rectification in the month in which omission or incorrect particulars are noticed? Is it right to conclude that powers of such rectification is flowing from 39.9? Is it not really flowing from 38.5? Because in this case, the ITC, the error was relating to ITC. And if we see the GSTR 3 scheme, the Form GSTR-3 which they had notified, the part is auto-populated, where the ITC details are auto-populated. So is it right to conclude that circular is getting power from 39.9? Sir.
First of all, I have to thank your team for inviting me, as also for the wonderful presentation that both of you have done, giving the scheme of return filing as well as the analysis of the Delhi High Court and Supreme Court decision in such a short time. Very well done by both of you.
Thanks, sir.
The first thing that we should remember is simply this: the the assessment under section 59, which is sought to be done by the assessee, no doubt is based on his books of account. We are not saying in any manner that it is not based on the books of accounts. It is based on his books of accounts. The simple issue here, without getting into technicalities, is this: I have filed a return. Let me put it in layman language. I have filed a return. I have indicated X as my input tax credit. Now, I find that in my earlier regime, I had a centralized registration. Now, decentralized registration, I have been registered in all the states. Naturally, I have missed out a lot of invoices on which tax has been paid by the supplier. Please note this point. The tax has been paid by the supplier. I get those input services invoices. I don't take the credit. Maybe the documents have come late, or whatever be the reasons. It is a period between July 2017 and September 2017, to which actually the circular doesn't apply. Let's be clear. In this period, I have left out certain credits. Simple question is, can I go back to that period and rectify the returns and show my credit? This is all. Now, I don't see why so much of halla-bulla was done on this, So the Delhi, before the Delhi High Court, Rule 61 was challenged, was clearly challenged. Rule 61 was amended with retrospective effect, no doubt. But what the courts also did not see was subsequent to that, Rule 61 was again amended and brought into force from 1/1/2021, where they refer to GSTR-3B as the only return. They have deleted references to GSTR-3. That is one part of the story. So the simple answer to this is, the challenge before the Delhi High Court was whether Rule 61 is valid, not valid, whether the circular is valid, not valid, and whether I can rectify my return or not. And all that the Delhi High Court said was, okay, we will not get into the challenge business. We'll leave it for a moment. We will look at it practically. Now, you have announced an elaborate scheme of filing of returns, matching of credits under 37, 38, 39. Most of it, as you rightly said, is self-auto-populated. Now, that entire scheme now is still not working. Even as we speak today, it has been disbanded. So what happens? The assessee is left with no option but to rectify his returns. Now, his rectification of returns, when I say I filed a return for a particular period, and if that return is wrong, the first question that should have been asked is, why is there no right to rectify a return being prescribed? That is the question that should have been asked. And that right is traced back to 38, not 39.
Right.
I go back to 38 because that is the matching of input tax credits.
Right.
So when I go to 38, that allows me this rectification, even now. Now, only if I can't do these things, as a last resort, I come to 39.9. That is why, please understand, 39.9 starts off saying subject to 37 and 38. Why it says that? It says you first attempt there.
Right.
You have, even after all those things are not done, come here. And if you've not done it in those months, then you do it after you take. Now, it is a facilitating mechanism. Please understand what the law is trying to say is this. I have given you certain auto-population, facilities. I have given you facility to match and rectify. Now, I allow you that opportunity. You do it to the maximum extent. Even after that, if you cannot do it, come to 39.9. This is what it is.
Right.
Now, a facilitating mechanism has been converted through ingenious arguments into a completely, failure mechanism. Therefore, my answer to your question is that circular doesn't apply at all to the facts of the case. The simple question before the courts was whether the rectification should be allowed in that month itself. There were adequate provisions in the GST Act to allow such rectification. And that rectification could simply have been done by going back to the return and filing. Now, one of the arguments that was used was, and wrongly, there will be chaos in tax administration.
Right.
Now, if you don't have a matching concept at all in the months of July to September of 2017, and it was introduced only in 2018, where's the question of chaos in tax administration, my dear? Matching system is not there. What is your problem in allowing the rectification? I can't understand this. You could have simply allowed the rectification, because please understand there are two things. The tax is already paid by the input service provider. If the tax is paid by the input service provider, I'm only taking the credit. What is wrong in me taking that credit? You have collected the tax already. So I believe somewhere, this difference between me taking the credit after the tax is paid and me paying an output tax where there will be a cascading effect of taking credit has been confused.
Noted, sir. Yeah, on the points. Another point, which the court have heavily relied is the self-assessment scheme under the GST. They have compared the self-assessment scheme of GST with the erstwhile self-assessment scheme and categorically said that it is similar to the erstwhile regime. While if we read the provisions under the GST law, it automatically, adds and deletes the liability overall self-policing system. If you are claiming the excess ITC, if it is not matched with the supplier's details, it would be reversed. So is it right to say that the self-assessment scheme under GST is totally same as self-assessment scheme under the pre-GST regime?
Sir, the answer is no.
Yeah.
The simple answer is that under the service tax regime where Bharti Airtel was there, you are filing 6 monthly returns. You may have been paying taxes on a monthly basis, but you are filing 6 monthly returns. And there was a provision in the Finance Act 1994 to even rectify the returns. Now, self-assessment, what does that have to do with the rectification of my returns? I have not been able to follow this part of the argument at all. No doubt it is self-assessment. I am not disputing it is self-assessment. I am not disputing also that I have made an error. I have made an error. I have not taken the credit. Now, there's one important thing which I want, I think you would have probably noted it. The Delhi High Court asked the department, file an affidavit as to why rectification should not be allowed in the same month. Delhi High Court records this saying that the government has not filed an affidavit on this issue. And even when there's a specific mention of this, which means to say your affidavit which the government files says that I don't know why this has happened. If that be so, you could not have improved your case with some other affidavit to the Supreme Court. This point should have been noted, because finally, if you yourself as a government are saying that I don't know why rectification cannot be allowed in the same month, there's nothing wrong with it. If that is your stance before the Delhi High Court, you could not have taken a separate or different stand before the Supreme Court. And self-assessment was not an issue in this. I'm not saying no. I'm not saying my records are pakka or my records are so good that I can claim this credit. I have come to you on the basis that my record keeping is wrong. Can you penalize me for this? That is the question asked. So my understanding is that the service tax regime and the GST regime are completely different for one more reason. The matching of credit was never there in service tax regime.
Right.
It was there in the VAT regimes in the states.
Right.
It was not there in the service tax regime. So the scheme itself of matching credits, etc., was completely different. So I don't think that question can be answered with any conviction to support the reasons which are there in the Supreme Court's decision. I'm sorry to say this.
No, sir. We all need to, follow. There's a big court in any case.
True.
Yeah. Okay. So one more interesting observation when we were analyzing this judgment is that the circular dated December 2017 was kept in abeyance, right?
Yes.
During that first 3 months, July, August, September, I was not aware that the government at later stage would come up with a new circular where they will say that rectification would be allowed in the respective month only. So during first 3 months, in a good self way, I have complied with the original circular. I was understanding, okay, I'm today paying the amount in cash. Tomorrow rectification will allow in this month only, so I can claim at a later stage this refund. So giving the retrospective effect of this December circular, what is your views on that? Is it right to conclude this particular?
See, it is like this. The circular was issued assuming that this was operational. The entire GSTR 1, 2, 3 business will become operational, and this is how the scheme is. In fact, this circular should have prompted the Supreme Court to think as to why they issued the circular in the first place. What was the intention of the government? The intention of the government was always to allow rectification in that month only. That is supported by your provisions in section 38 bracket 5, I think, if I'm not mistaken.
Right.
Rectifications have to be done only in that month. And if you don't, then only you go into 39.9, as I earlier told you.
Right.
So always the intention of the government was to allow rectification in the month in which you have entered into these transactions and is getting reflected or not reflected, as the case may be, where both the parties will then, sit and match and then report. Now, the abeyance was to the effect that because we don't have the system in place, we are keeping it in abeyance. That does not take away the fact that the government always wanted the rectification to be done in that month only. This should have been emphasized, I think, or may have been emphasized. We have no way to know how it was done. But if this was emphasized, probably the Supreme Court would have seen reason in this. Probably. And said, yes, this was your government intention. You changed it later to another circular which says in the month in which it is noticed. Right. That is a paragraph 4. This is what prompted the Delhi High Court to say, okay, fine, your intention was this. You changed this intention later on. Now you tell me through an affidavit, what is your intention? That affidavit was not filed in the Delhi High Court.
Right.
That is very important. Now I cannot take a different stance in the Supreme Court than what I filed in the High Court. See, this is a very unfortunate thing. Way back, I remember there was one case, Gordon Das Banji's case, AR 1952. You will find this case. The Supreme Court says you cannot improve your case beyond the order that you have passed. Because there is a very funny thing that happens in these government circles, which I may tell you. I pass an order. The affidavit keeps improving on that order. The affidavit filed several months after the order is passed, an appealable order or which I go in writ. Government files an affidavit explaining what that order is, actually why it was passed. No, that the order itself should say it. That is what the Supreme Court warned. They said you cannot file an affidavit and explain the order. Let the order itself explain it. So therefore, in a writ proceeding, the affidavit has a lot of importance in the absence of any orders. If in that affidavit you have not given what is the reason for not allowing rectification in the same month, it is quite clear that the Delhi High Court was therefore correct to assume that you had absolutely no defense.
Right. But sir, the point I want to know, all these arguments relating to whether circular is valid or not, is it on a different footing? The point which I was trying to highlight is that even if it is valid, just for 1 minute if he assumes, even in that case, during first 3 months, I was not aware that this circular would tomorrow come. So I have done things in a good self. The circular which you have already, clarified that rectification would be allowed. So how the conclusion can be made with using
Yes.
circular.
Yes, you're right. You're absolutely right. Because it is simple. July to September, I have made some errors.
Right.
Now, I don't know that the government is going to issue a circular in December, unless I am a very good astrologer.
Right.
Now, having not known it, I have made some errors. Simple case. Now, I discover much later that my invoices are not matching. Finally, I've paid tax that time in cash. It was not an option. I have not recorded these invoices at that point of time. I want to go back to that point of time, record these invoices. 923 crores has been collected from my customers. I mean, I am the customers for them, actually.
Right.
My suppliers have already paid the 923 crores. All that I'm saying is I'll take the credit. This is all the cases. So you're absolutely right. And error which was caused in the initial stages of the GST implementation. Rectification should have been allowed, whether there is a circular there or there is no circular there. And there is no way I could have known whether a circular will come or not come also.
Right.
And on that ground itself, it is reasonable to assume that I should be allowed the facility of rectification. Simple.
Okay, coming on to the next, a very important observation. I think this would have a lot of impact on ongoing litigation. The Supreme Court, I would say, have concluded that common portal, that is GST system, is only a facilitator, and it is to feed and retrieve the information. It is not a primary source of doing self-assessment. So they concluded that on GSTN portal, the things which are coming, it cannot conclude your self-assessment. You have to do on your own. So we have lots of show cause notices and litigations have started relating to 2A 3B mismatches. So sir, what is your stand? Will this judgment would going to help us, or how department would going to react in future relating to this issue?
Yeah, they will take a completely contrary stance. You just see when it comes up.
Oh,
you wait for it. I'm openly telling you this. I'm not at all mincing words in this section. I'm openly telling you this because 146 says facilitating filing of returns. Let me ask you two simple questions. Can Bharti Airtel or any other assessee tomorrow say, since the facilitation is not happening properly, I will file my GSTR 1, 2 and 3 manually? Could I have said that between July 2017 to December 2020? Could I have said that I will stop filing my returns through the facilitating portal because it's not facilitating? I will file it manually. You could not have said that. If you can't say that, the portal is not a facilitator. It is a compulsory portal in which I do my operations. 1. 2. If you are saying that it is only a facilitator, then Rule 86A has to go completely. You cannot block the credit through the portal because you're not facilitating. You're blocking my credit. How can you facilitate? This is a fundamental error to say that if you're saying that it is not a primary source of assessment, you're right. Primary source of assessment is my books. Absolutely right. But if you're trying to say that the portal is only a facilitator and therefore is not going to matter to you in terms of assessment, then all the cases which are there on matching will have to automatically go. Let us see what kind of affidavit they are going to file. At that time, they will find an ingenious way of telling something else. But we will wait and see what kind of affidavit the government will file. But I am quite clear that this decision can be used for all those purposes. In fact, even without this decision, we could have won that case.
Right.
What was not noticed is that the section 43A has not even been introduced. Even though it is in the statute book, it has not been notified. So even that point has to be kept in mind. So in my humble view, this decision is quite useful in all those section 16(4) cases. I'll tell you one more thing where it is useful. If I have not, if I have recorded something in my books of accounts and not recorded it in the portal, then the limitation under 16(4) will not apply. Are you getting what I'm saying?
Yeah, I'm getting, but how?
See, 16(4) says you should have taken the credit before September of the next year.
Right.
Correct? You have a maximum period that is up to 18 months. Right? Now, I could have taken it in my books and not loaded it in my portal.
Right.
So, in all the cases where I have taken the credit in my books and not put it in the portal, the time limit does not apply because the portal is only facilitating. My primary books of assessment, credit is already reflected within 18 months or within that 1 year or within September of next year. If that is my stance which I can take, I can use Bharti Airtel case to my advantage. So to that extent, you're completely right. I can also use it in all 86A cases to tell,
Right.
No more you can block my credits because you can only facilitate the credit.
I got that, sir. Okay, so this would overall, if we talk about, if we conclude this point, it would, be a savior for all the show cause notices and litigation for mismatches, issues relating to 86A.
Let me interrupt you and tell you all those matters also will go to the Supreme Court. You wait and see.
Yeah. Even we have noticed, few of the issues relating to COVID era where people couldn't take the ITC within the time limit because, offices were not there, invoices were not getting accepted by the suppliers and they asked the supplier to issue a credit note, etc. So this all chaos created practically during the COVID era also. So obviously this would come in near future, we'll see it. Coming on to sir, very important question. I know the government has categorically taken a stand, but I would want your views also on this point that, can we still call GSTR-3B as a return because it does not have a fundamental matching concepts. It is manual return. Though return has been defined under the GST law, which says whatever you prescribe in the rules also, but still it is not having all the fundamental things which is there in the GSTR-3. So even after retrospective amendment made in 61.5 multiple times, can we still argue this point and what is the weightage of this argument?
Yeah, I will tell you. The parties and the courts have not noticed that 61.5 was again amended in the entire rule was replaced to be effective from 1/1/2021.
Right.
See, up to 31/12/2020, both GSTR-3 and 3B were called returns in the rules. So Gujarat High Court rightly said that this is only a memorandum. You see, please see the council minutes. The council minutes are very clear that it is a stopgap arrangement. Very clear. Only after the ARP judgment came, the council says we have to amend the law. They don't discuss or say 3B is not a stopgap. They don't say that. They say we have to amend the law. Now, after having said so, what do? They amended the law with retrospective effect, but they forgot something which you would have noticed. GSTR-3 continued to be under Rule 61.1. 3B continued to be under 61.5. So we filed petitions challenging that 3 continues to be still the return. They realized that mistake and then substituted the rule with effect from 1/1/2021 to delete references to GSTR-3 and only specified 3B. So up to 31/12/2020, GSTR-3B can never be called a return. Now, let us come to the other part of it. On the statute today, you have GSTR, the matching concepts, etc., everything is specified. Nothing of it is on operationless except a few of the section, provisions through the rules. So therefore, you're absolutely right in saying that you can still challenge 3B and say you have never envisaged this as your original return.
Right.
This point, unfortunately, this point was not actually germane to this case at all. Unfortunately, the AAP judgment now has been foreclosed. The challenge which is now pending in the Supreme Court has got foreclosed, with the Supreme Court categorically saying that it is very much a return. But probably when this matter comes up for argument in AAP's case, if the people who argue are able to show that 61 was actually substituted from 1/1/2021 and GSTR-3 was completely removed, then probably the Supreme Court would see the entire scheme, and we hope that Bharti Airtel will be referred to a different bench of a larger strength as regards this point. Or I would only say that this has to be treated as an arbiter.
I got that, sir. So, considering the availability of time, I request you to conclude the judgment, if you can,
Yeah.
What is your overall take on this judgment?
My overall take on the judgment is, well, it's very well written, actually, because the judge has painstakingly gone through all the act and rules and come to a conclusion. The only thing is that the focus of the judgment was on self-assessment and the fact that you cannot blame the government if your books are not proper. That was the focus of the judgment, where I felt, probably in my humble opinion, the judgment should have simply focused on whether you can rectify your return or you cannot rectify the return. That's it. Let's leave the other things aside. There are errors of the government, there are errors of the assessee. Both have created errors in this. So all that the court should have, I think, in my opinion, focused on is simply this. Can you rectify? Can you not rectify? Or given the fact that it is a matter which fell between July to September 2017, you please rectify this considering your powers under 142 of the Constitution. You could have passed directions there also saying, yes, you could please rectify. After all, the tax is collected. So in my humble view, rather than going into the challenge to the rules and other things, it could have simply been sorted out by saying that like what the Delhi High Court said is that the returns, if you allow him to file a return, you should allow him to rectify it also. And such a rectification should go back to the date when the returns were filed. And in the initial stages when errors were done, you should allow that rectification to happen. And because there was no matching, there is no cascading effect.
Right.
So in my humble view, these points should have also come out in the, probably in the order of the Supreme Court, which is actually very detailed, much more detailed than the Delhi High Court. But I think the focus should have shifted to rectification of returns rather than, a blame game between the government and the assessee. That should have been avoided because both have made errors.
I got that. One question I would like to take from the participants is very interesting. So what do you think? Is it a good case to file for a review petition?
Review petition is going to be tough, sir, in these circumstances. Review petition is going to be tough in the circumstances. I don't see how this review petition will be entertained. Because there are several reasons the Supreme Court, you can tell like me that analyze the decision and say these are all the errors. But it's a point of view which the Supreme Court has. You have to respect it.
Right.
File the review petition. Nothing wrong in filing the review petition. But you have to respect the decision made by the Supreme Court.
Right. So with this, I'd not be able to take the questions asked by the participants considering the...
A couple of questions, if you feel, please go ahead.
Sure.
Please.
So just give me a minute, sir. Let me read it. So Mr. Rajesh has asked that, do you think that the case has not been well argued before the Hon'ble Supreme
No, you had one of the best advocates arguing it.
Harish Salve and
Yeah. So you have to, you will not. I will not be in a position to say that because they would have argued elaborately.
Right.
What kind of submissions were made and what is the quality is something I should refrain from commenting.
Another question is, what would be the fate of 16.4? I think sir has explained.
I've explained this already.
Yeah. GST and subsume both state and central taxes. It is incorrect to say that to compare the GST only with the Finance Act.
I fully agree.
VAT. The speakers should have considered both central and VAT. So sir is agreeing on the same? Yes, VAT needs to be.
Absolutely. See, VAT had matching, while service tax never had matching.
Right. Even if I would not claim, so this is just a comment. Last question. Sir, as per Supreme Court verdict, GSTR-2A has got no relevance and merely a facility. So can we continue that finally 2A is not legal?
Absolutely. You can now fight on 2A completely.
Right.
Absolutely.
So I believe that this discussion was fruitful for all the participants because I'm very sure Karishma and I has really enjoyed this discussion with Raghuraman sir. And with this, I thanks to all the participants for joining in today's webinar. In case you have any queries from us or Raghuraman sir, you can write it to us. We'll forward to Raghuraman sir for his kind views. The PPT we would be sending you over the email, and the link of the webinar, the recorded webinar, would also be sent to all the registered participants over the link. Thanks for joining for today's session. Thank you. Thank you, Raghuraman sir, for joining us.
Thank you very much. Thank you, sir.